position, because when Amichai invited me to take part, he said he wanted me to be both a moderator and a commentator. Yet we only have 10 minutes. I'm reluctant to take up all that time, but you will excuse me if I do take up a few minutes. And I'm going to relate more or less to some themes that came across. First of all, I want to thank Ariel. Ariel was a student of mine as well as he was of George's, and I think the greatest compliment that a student can pay his teacher is to take what the teacher said and subject to criticism, and I thank you very much. Fundamentally, I don't think that at the present time there's great disagreement between Ariel and myself on one issue. And that is the issue of the application of humanitarian law in what are non-international armed conflicts. In an article which you haven't seen and which will be published in the next few days, I also took the line that you took, that we should only apply the law of war in non-international armed conflicts when we have a very, very high threshold of violence. The problem is that that does not reflect international law as it's stands at the moment. And when dealing with terrorism and counter-terrorist acts, we've always got the two fundamental questions which came up here. Which legal regime is going to apply? Are we talking about a law enforcement, criminal justice, human rights regime? Or are we talking about an armed conflict model? But second of all, and I don't think that this was addressed enough now, assuming that we have the armed conflict model. And in my mind, that's a big jump. Assuming that we have the armed conflict model, which armed conflict model are we talking about? And there are two very different models. The one model is the model of the international armed conflict, and it's in the context of that model that the International Committee of the Red Cross has said there's no such thing as an unlawful combatant. And that is clear, and I think they're 100% correct. There can be civilians who are taking part in hostilities and they can be treated as such, but there's no such category as an unlawful combatant. When you're talking about non-international armed conflict, the biggest problem is that international law doesn't even define who is a combatant or if there is such a combatant in such an armed conflict. And so here is your fundamental problem. And then there are two views when it comes down to that. And the one view says, well, there's no such person as a combatant in a non-international armed conflict. There are only civilians taking part in hostilities, which I've never accepted. And the other view says, well, let's call them something else. Let's call them fighters. They are fighters in non-international armed conflict. It works in English. It doesn't work in French. It doesn't work in Spanish. And so we have a problem. Now, where then do I take issue with what Ariel said? If we were to go according to your model, that we would only use the law of armed conflict, where we have a very, very high threshold of violence, then I think we've got the human rights model, and we've got to address the kind of question that you addressed, which is of itself problematical, because when you start talking about derogations, and you can't derogate from the right to life, and I'm very, very reluctant to accept that you could have a legitimization of the use of lethal force against the enemies of the state on the notion that it's absolutely necessary when there's no imminent violence. I think it opens up something that I'm not so sure that I want to open. But if you're playing with the rules as you have them, and you've got Common Article 3, which according to all the literature does not regard a very high threshold of violence in order for it to apply, you have this tension between application of Common Article 3, because you have a non-international armed conflict, and yet if we're talking about the typical non-international armed conflict, which is an internal armed conflict taking place within the territory of a state, it's clear that human rights law still applies. And so you have to have some meshing of these two. There's no way you can avoid it. There's nothing in human rights law which says, and I'm not talking about international armed conflicts, that if there's an armed conflict taking place within the territory of the state, suddenly all the law is replaced by international humanitarian law. It doesn't exist. And I think it is highly problematical. And I think the biggest issue that we've got to address, and this is where Daniel Reisner comes in. Daniel Reisner says, well, I don't want the human rights model, I don't want the international humanitarian model, I want some third model. Well, that's very nice. But as he knows better than anybody else, when he was a legal advisor, he had to try to work within the existing models. Out of those models, we may in time create a third model, but the way to create that third model is working within the existing frameworks and trying to develop something. So now Ariel's trying to do that in one manner, which I appreciate, and he follows the European Court of Human Rights, which in a very unsatisfactory way, in my mind, in dealing with Chechnya and some of the Turkish actions has done the same. I think that another way is to try to see, well, in non-international armed conflicts generally, how do we mesh together the rules of human rights law, which have to apply, and some rules of international humanitarian law apply because of the application of Common Article 3. But I'll leave it there, and now let's see if we have any questions or comments. We'll try to make them short. Sigal.
Thank you very much to all the presenters, and I wanted to fully agree with everything that Professor Kretschmer just commented and add to that, that if we concentrate on the model of non-international armed conflict, we can solve a lot of the problems that were raised, not only with regards to the distinction between combatants and non-combatants, but also with the issue raised by Ariel Tzemach about the principle of equality. We can perhaps motivate states to agree to comply more with norms of international humanitarian law through applying this model, since they're still, in the context of a non-international armed conflict, allowed, according to additional Protocol 2, to use whatever forces they need to use to defend themselves and reestablish law and order inside the state. Obviously, they'll be confined to international human rights law. But basically, the principle of equality, I don't think applies so much in the non-international conflict, since the state can target under certain constraints the fighters of the other side, and can also prosecute them for targeting its fighters. And I think in all the presentations here, there was an underlying assumption that the conflict between Israel and the Hamas or Hezbollah, as well as the U.S. and Al-Qaeda, is an international armed conflict. There was no real discussion about that, and I would like to challenge that.
Okay, but
it just solves a lot of tensions if we try to think about it as a non-international, there's theoretical grounding to that.
Just a moment.
Yes, thank you, David. My question is for Professor Bradley, only partially because he identified the organizations in which I work, I just want to pose a question to him in respect of the third category, unlawful combatants category. And I guess I just have a fundamental question on how that really addresses the central issue. Here you have fighters, combatants, call it what you will, who fight without a uniform, blend with the civilian population, hide behind the civilian population, fight in built-up areas, resulting in the problem, which is the destruction of property and civilian casualties. So how does this third category go to the root of that and solve that problem? And I just want to clarify what our position is on these two categories. And maybe it's a result of 9/11 and some of the stresses that were placed. There is certainly a recognition within our organization as well as internationally, but the lack of definition on direct participation and as a result of several expert meetings and we've come up with some interpretive guidance, but I think our position is also evolved. It's not a black and white category, and I think highly relevant to this context and the recent Gaza conflict, there is an acknowledgement that you can target somebody who's a member of other organized armed group for the duration of his mission, not only while he's attacking or in a direct planning of an attack. And that this applies in international as well as non-international. So it may be an evolution, maybe a stretch, you call it what you will, but so I don't think the two-category approach is so categorical as it was.
Okay. Daphne?
2.5.
I'm afraid we're going to have to take this as the last question, because I was told to end at 1+1. I've given us another 5 minutes, and then may want to respond. Daphne, and last question.
I want to build on the presentation of Professor Bradley and Professor Fletcher. I Professor Bradley, you mentioned that we can perhaps stretch the categories of civilian combatants to two main categories, and you spoke mostly, I think, of stretching the category of civilians. And I'd like to raise the question of whether perhaps we should think of stretching the category of combatant, or perhaps reinterpret it or rethink it. And one way we could do this is actually through the use of Michael Walzer's example in the case of the soldier who is smoking a cigarette or taking a shower, and in the words of Walzer, I believe, regains his humanity, becomes a man again, and in other words is the fact that he's not conducting any more combatant-type activities, ceases to be targetable because his conduct takes over, takes precedence over his status, according to Michael Walzer. So where I go with this example is that I use it together with other historical and legal arguments to support the view that perhaps if we switch our focus, our emphasis from membership within the armed forces to status, in other words, if we pay more attention to what it is that people are doing, are they taking a shower or smoking a cigarette, or are they engaging in warlike activities, then we can rethink the category of combatants and perhaps, using this example of Walzer, expand that category or try to adapt it to the reality, and that's the legal consequences that I drew from the example of used by Michael Walzer, and I'd be interested, Professor Fletcher, to know where you're going with that example, because I don't think you had a chance to go until the end, and I'd appreciate it. Elaborate. Thank you.
Okay.
Maybe I'll just address the Red Cross comment, which I thought was a very helpful one. I think it's great if organizations like the Red Cross, which are very influential, recognize the need for adaptation and evolution in this area. Your statement sounded a little more definitive than what I had read in a bunch of other ICRC publications, including the summaries of these expert meetings on direct participation, where it said there's a whole section on membership, and it said there's significant debate among the experts. It didn't seem as nearly as, at least there wasn't as much consensus as what you just described there. But if there is, I think that's a positive development. The question is, how does having the third category help in the situations we're dealing with? I do think that absent some kind of significant change in how true non-combatants are addressed, that the targeting, for example, is easier under the third category approach. Now, we can debate the examples, whether these are good examples or not, but the United States or some countries using drones or things like that, for example, in the conflicts in Afghanistan or Pakistan, I think it's much easier to justify and explain that under international law by talking them as analogous, as if they were analogous to traditional fighters. That sort of goes to the question of the person smoking a cigarette. And maybe the alternative, what I'm saying, is to say, fine, treat them like combatants, but obviously restrict what one can do with respect to combatants. If that were the evolution of international law, my argument would simply be for some sort of equivalency here, although I don't think international law has gone in that direction. If we saw a convoy or trucks not really engaging in battle at the moment, I don't think there's any question that in a traditional conflict they would be a legitimate military target. It's harder to explain that without a third category. That would be my argument. Now, people were raising the issue, and David did, about Common Article 3. If it's true that international law allows for unlawful combatancy kind of framework there, I agree, that's fine. The U.S. Supreme Court has said we're in Common Article 3, and I doubt there's consensus on that. Many people argue that in non-international armed conflicts, there are no combatants. I think that's a bit absurd if you think about many non-international armed conflicts. The U.S. Civil War is very prominent in people's mind in the U.S. They were treated as combatants. And, but what about guerrilla groups? They were certainly not treated as lawful combatants. They were tried for their crimes in military commissions in over 4,000 military trials in the Civil War. This is not a novel concept. This is the idea that there could be fighters who don't qualify as somebody who gets to engage in combat. And people who've written about this after the Geneva Convention, Richard Baxter's famous article on unprivileged belligerents makes the same argument in the 1950s. And so there's something in my mind unrealistic about saying that people who are not lawful combatants in a non-international armed conflict and maybe not recognized as engaged in a lawful enterprise are all civilians, even if they're fighting and doing things that combatants traditionally do. And to go back to my earlier comment, I think international law needs to be realistic about what states will do to accommodate the security needs. And I think that idea is not very realistic.
Ariel, do you want to answer?
To refer to Sigal's comments, it is true that the law does not apply equally to state and non-state entities with regard to the issue of prisoner of war status, who is entitled to prisoner of war status. But it does apply equally to state and non-state actors. With regard to the question, how broad is the permission to kill? Whom can we affect, whom can we not affect with regard to warfare methods? Without that, no more doesn't have equal respect in my
The answer to the question about the unlawful smoker by the river, I think that a lot depends on the context in which I will be expressing my opinion. If it's a judicial context, I would say no crime, no prosecution. If I'm lecturing to future soldiers, I would say don't shoot. But I don't think you're required as a soldier to take risks to yourself or to your company, to your fellow soldiers, just in order to protect enemy life. So I think in the context of self-defense, under criminal law, you are required to take some risks in order to avoid shooting. You're riding on the subway, you feel like you're in danger. That's not enough, right? Even if you see people who are dressed like people who might attack you, that you think that they're dressed like people from Queens who might attack you as a Baguette's case, that is obviously not enough, right? So uniform doesn't matter, it's all content. But in the military context, status is everything, unfortunately. So I don't think it's very pleasant to be a soldier. I don't think it's very nice, and I would find it difficult to tell the soldiers, lecture to instruct soldiers, shoot. But as a prosecutor or a judge, I would never convict them.
Well, I want to thank all the speakers, and I want to thank the audience and those that asked questions. Now we break for lunch. Amichai?
Yes, so
ambitious task to keep us awake after I saw what a heavy and good lunch that you got, but I hope we are going to wake you all up with a very interesting presentations on the basis of papers that I've read and enjoyed tremendously on the matter. My name is Yafa Zilberschatz, I'm from Bar-Ilan University, and I will be chairing this panel. Whenever I get to read anything about legal devices and means to refer to terrorism, combat terrorism, I always think about the ambitious aim that we have at our generation, because usually war between, human beings are very special creatures in the world. They fight each other, which is something that we have to consider and think about it from other aspects, but the legal aspects. But being that so, usually the fighting among people were in wars between states. And thus the law, and mainly international law, developed the rules about what is allowed and what is forbidden within, I would say decades, long decades. I won't say centuries, but probably long decades from the 19th century and on. And we have a heavy body of law describing the laws of war. Now, the recent decades in history are that the war against terror, the main war between people is not necessarily among states, but also between individuals who do acts of terror outside their state. And the law, to a certain way, was unprepared for coping with this big problem. I think that the panel is going to give a very interesting, both from a constitutional and administrative law perspective, criminal law perspective, and international law perspective, additional knowledge and equipment to deal with this complicated situation that humanity is facing today in the war against terror. Our first lecture is going to be by Professor Daphna Barak-Erez from Tel Aviv University and Professor Matthew Waxman from Columbia University, and they are going to talk about secret evidence and fairness and in terrorist detention, comparing common law models. I would say that the idea about secret evidence is really a thing that we in Israel are coping with for many years. I would say even before the recent situation which forces us to do it. And to a certain way, we did develop our system on the matter, which you will elaborate, and then you bring also another system as another method which can be adopted. And I think it's going to be, if I understand properly, mainly speaking to the American legal system, just looking about what happens in the world and really trying to study and adopt. You don't recommend anything which is better than the other, but you just recommend to look at the system and see what to do with secret evidence, which is going probably to be a big thing in the United States, while they start regular legal procedures after Guantanamo is going to be not in existence any longer. So please, the podium is yours. You can start. Thank you.
Well, thank you very much. It's great to be here, and I'm particularly grateful to be here collaborating with my friend Daphna Barak-Erez on a common project that we started some time ago, and as you can see from the draft, is still very much a work in progress. But it's a perfect project to present here because we are interested in what kinds of lessons can be learned from looking at other systems, other legal systems that share some common baseline principles, some common foundations. So the problem that we're interested in is the following question: how should legal systems like ours, like the United States, like Israel's, handle classified or secret information that cannot be consistent with security imperatives shared with a suspect facing some major deprivation of liberty? So the paradigmatic example is a detention hearing. I should say from the start, we're not looking in this study at the use of secret evidence in criminal proceedings. We're looking at civil or administrative proceedings that involve some major deprivation of liberty. One reason why we exclude criminal cases is because of some unique provisions in various national constitutions, like the Sixth Amendment in the United States, which provides for certain confrontation rights. We kind of want to standardize our study across the different systems. So what we're really looking at is how have different common law systems with Anglo roots dealt with the secret evidence problem, and how have those systems interpreted or wrestled with the problems of reconciling the need for some secret evidence with what we call due process, other systems call fundamental fairness. Again, sort of a classic example might be, let's say you had a detention hearing where the critical piece of evidence against that suspect comes from a confidential informant that continues to provide a live stream of important intelligence information. You can't disclose to the suspect exactly who your source is inside that terrorist organization. We have two main objectives in this. One, a descriptive objective, and one, a normative objective. Descriptively, we're interested in looking at how have different common law systems with common Anglo roots. In particular, we're looking at the United States, the United Kingdom, Israel, and Canada. How have they arrived at actually some quite different answers to this common problem that they faced? And then normatively, looking forward, which of these approaches taken by these different national systems sort of works best? And just take one more step back, what do we mean by best? This is something, the paper is really framed in terms of American law reform, because this is one issue that we're wrestling with right now in the United States. In the Boumediene case, the Supreme Court said that detainees at Guantanamo have a constitutional right to habeas corpus, which includes a meaningful opportunity to refute the allegations against them. The Supreme Court did not give any sort of clarity or detail on exactly what that means to have a meaningful opportunity. And the Supreme Court even identified this problem of secret evidence as a particularly important and difficult one, but delegated in the first instance to lower courts or perhaps to Congress to try to formulate some answers to these kinds of questions. So we're hoping that this study can help fill in some of those details. I'm going to turn it over to Daphne to talk a little bit about the comparative work.
So I'm also very much delighted to be here and cooperate with my friend Matt. And I also have another confession to make. Although the paper looks at U.S. law reform, I mean, for me, from my perspective, it was an opportunity to think also Israeli law, or I mean, what we are really interested in thinking about is what do we think, how would we, describe a fair and accurate solution. Again, there is a need to define here fairness, but it's not only about American law reform, although this is the way the paper presents the matter. And my role, I mean, in this separation of powers between me and Matt, I will describe to you very briefly the models that we detected and the basic features as we understand them based on the case law. So since we discuss systems that all share some common denominators, I mean the British legal culture in the broad sense, so we start with the concept of natural justice, which is the basic concept of fairness in common law, which includes, among other things, the right to confront, to bring, I would say, arguments against accusations that are brought against a person. I'm talking now about an administrative process, not only the obvious right to confront allegations in a criminal case, as Matt already said. And as part and parcel of this concept of natural justice, when one is entitled to bring arguments, these arguments have to be based on some facts that were disclosed to the person, because otherwise the whole process is without any purpose and no feature of fairness. Having said that, according to this tradition, it is possible to disclose to the person only the core or the gist of the allegations and not necessarily everything. And this is not a new concept. I mean, this has always been part of the understanding of natural justice. But the real question, which is intensified in the context of anti-terrorism law, is to what extent can we suppress the gist, the core? I mean, how low can we get? I mean, as the system, when we still want to retain a concept of a meaningful gist or core requirement. Because if we tell a person, well, the allegation against you is that you are a Hamas member, for example, this is probably not a very meaningful way of conforming with the idea of natural justice. We're saying something, but in fact this is meaningless. So there isn't an understanding that some core should be protected or has to be there. But again, the question is how low can we get? And this is exactly the point that is very controversial. And we look at a recent case law, for example, from the UK, with a series of control orders.
But we have come up with a number of insights that we think are important, that we're trying to develop further and that are useful, certainly within the United States, as we wrestle with different alternative formulations to this problem. One question is, if we take seriously this idea that fundamental fairness or due process requires disclosure of the core or the gist of allegations, right? If that's really a critical element, that nobody should have their liberty deprived of them without disclosure, at least of that core or gist. One important question is, do these models protect the gist, or do they erode it? Right? One of the justifications generally for each of these models is that they help protect the core or the gist. Especially the special advocate is seen as somebody who can expand, who can push for more and more information to be disclosed to the suspect. Our own research indicates suggests some caution with regard to both the judicial management and a special advocate approach, which is that as courts become more and more comfortable with some alternative mechanism to telling the suspect what the allegation is, whether it's the courts through judicial management becoming more and more confident in their own ability to scrutinize information, or become more confident in allowing some special advocate to argue on the detainee's behalf, on the suspect's behalf. Does that result in actually trimming down the amount of information that's turned over to the suspect? Does that end up putting downward pressure on the gist as you add more and more additional procedural protection? So that's one question that we're looking at. A second question that we're interested in is, what do we mean by fundamental fairness or due process? To the extent that these systems, whether it's providing the gist of an allegation, providing for some judicial management of secret evidence, providing a special advocate to argue evidence on the detainee's behalf, all in the name of fundamental fairness or due process, what do we mean by those terms? And our reading of the cases leads us to hypothesize that the different systems that we look at interpret those terms in slightly different ways. One possible meaning of fundamental fairness, or one key concern behind fundamental fairness or due process, is what we call fairness as dignity. In other words, due process or fundamental fairness is about giving the suspect some right to participate in his own defense. If that's the case, then that tends to point systems towards a special advocate model, something that preserves this idea of adversarial contestation, and even if not allowing the detainee to view the evidence himself, at least provides for some proxy adversary on behalf of the detainee to preserve this idea of adversarial contestation. So one possible meaning of fundamental fairness or due process is this dignity value. A second interpretation and by the way, that first one is how we read the Canadian and the British cases really treating this area. This issue. Israeli courts, on the other hand, seem to talk about fundamental fairness in terms of accuracy enhancement or error correction. In other words, due process, fundamental fairness is about reducing the likelihood of error, in which case the preference for a judicial management model seems to reflect a greater confidence that judicial scrutiny is the best way in the cases of secret intelligence information to bring about truth finding. And then a third meaning of fundamental fairness that we're interested in, or a third meaning of due process, is more of a regulatory function. Due process as a check on the expansion of coercive state powers. And then the question becomes, which of these models is most effective in regulating or stopping what may often be an inevitable expansion of the government's use of highly intrusive, highly coercive powers. And then the question is, which of these models is most effective in combating that phenomenon. I would just conclude by saying that one of the insights that we want to explore further is this idea that ultimately one can't select among these different models for handling the secret evidence problem in a vacuum, independent of other institutional features of the system. So one of the features of the Israeli judiciary that's interesting in this case is the fact that you're talking about a relatively small group of judges that are repeat players in these types of detention hearings. And it's that repeat play that probably gives rise to greater confidence in a judicial management system as opposed to a larger, more generalist system, judiciary system that we might find in the United States, where you're unlikely to develop the same expertise in intelligence matters over time, and where a judicial management model is less likely to work unless perhaps combined with some sort of institutional innovation like a special national security court.